Welcome to the McNees Energy and Environmental Podcast Series. This podcast will address public utility law by Kenneth Stark, attorney at law. Mr. Stark practices in the Energy and Environmental Law Group at McNees.
Hi, thank you for joining me as we take an exciting whirlwind journey into public utility law. So what is a public utility? A company can acquire public utility status when that company is the sole organization that maintains the infrastructure utilized in providing an essential service to the public for compensation. What are essential public utility services? Today you may think of your gas bill, your electric bill, your water or sewer bill. Historically, public utilities have also been associated with telecommunication services, rail services, and other transportation or motor carrier services. A public utility is a monopoly because it enjoys exclusive control, possession, and market power over its service as the sole provider in a particular geographic service territory. A public utility becomes a natural monopoly due to high startup costs, high fixed infrastructure costs, and high operating costs. Regulation of public utilities developed in the early 1900s because governments determined that duplicating the vast fixed physical infrastructure would be too costly, unnecessary, and not in the public interest. Just think of multiple sets of transmission lines across the landscape or multiple sets of pipes in the ground. What are the goals of public utility regulation? Because public utilities provide essential, necessary services, there's high demand for these services. In order to protect consumers, a public utility's rates and services are heavily regulated. Service regulation ensures utilities provide safe, adequate, reasonable, and reliable service. Rate regulation determines prices a utility can legally charge to its customer classes. Rate regulation strives to replicate the results of effective competition. How does rate regulation work? Most utility and service commissions adhere to a just and reasonable standard. What is a just and reasonable rate? In a landmark 1944 case, Federal Power Commission versus Hope Natural Gas Company, the United States Supreme Court explained that when determining just and reasonable rates, the rate-making body should balance consumer interests with investor interests, or those interests of the public utility. A public utility is entitled to a rate that, one, allows the utility to recover those expenses that are reasonably necessary to provide service to its customers, and two, allows the utility an opportunity to obtain a reasonable rate of return on its investment. What is a reasonable return on investment? Return on investment, or ROI, is often a contentious piece in any rate-making proceeding. It requires an examination of the utility's cost of capital, cost of debt, and projected capital structure. In the Hope Natural Gas case, the Supreme Court held that the return to equity owners, or shareholders, of a regulated public utility should be commensurate to the returns on investments in other enterprises with corresponding risks. The return should be sufficient to assure confidence in the financial integrity of the enterprise so as to maintain its credit and to attract capital. With those overarching standards in mind, practically, how are utility rates determined? Typically, this occurs through an administrative rate-making proceeding, which is on the record, adversarial, and potentially very litigious. The utility will propose a rate increase through an extensive filing that includes mounds of financial data and overlying reasons for the rate increase. The case is set for hearing before an administrative law judge in a state or federal agency. Public input hearings are often scheduled so that members of the public may testify. Attorneys file notices of appearance on behalf of their clients representing various interests, from the utility to consumer advocacy groups to environmental groups and others that could be affected by the filing. A rate case is a trial-like setting. The discovery process kicks off with data requests, interrogatories, and requests for production of documents. Expert witnesses are retained. There are various motions and answers, briefs and evidentiary hearings. Today, more rate cases settle because litigating can be expensive, because governmental bodies have advocated settlements as in the public interest. That's a very brief overview of public utility law. If you have any questions about how the latest trends and developments in public utility and energy law could affect you or your company, please do not hesitate to contact us.